Welcome. Hello, everyone, and welcome to today's seminar, Demystifying the Baker Act, hosted by NAMI Sarasota Manatee and Mental Health Community Centers, all here in Florida. We're going to discuss the mental health law known as the Baker Act as it pertains to Florida law. So for our agenda today, you're going to get a brief introduction about our host organizations, and I'll explain today's topic a little bit. Then we'll hear from our two speakers and have a Q&A session at the end. So please send us questions all throughout the presentation as you think of them, and we'll answer as many as we can at the end. And you can do that in the Q&A tab in the Zoom app. And just to let you know, we'll be making the recording and the slides that you see available after the webinar at some point. You also might see a short survey pop up on the screen. Please fill those out. I'm Shay Kilby. I've been volunteering with NAMI for over a decade and currently serve on the board of directors here at the local affiliate. With us today, we also have Taylor Walker, who is invisible at this point, but she's our brilliant program coordinator at NAMI Sarasota Manatee, as well as our two speakers, Karen Lord and Lieutenant Charles Kenneth, who I'll introduce a little more thoroughly in just a moment. As I mentioned, this webinar is hosted by NAMI and Mental Health Community Centers. NAMI is the National Alliance on Mental Illness here in Sarasota and Manatee counties. Our local affiliate works to improve the lives of individuals with mental illness, as well as the lives of their families and caregivers through support, education, awareness, and advocacy. So we offer support groups, classes, and help navigating the mental health system when we can, and we have a lot more resources. You can find out more by visiting our website at namisarasotamanatee.org. You'll see that later on a slide as well if you didn't catch that. Also, Mental Health Community Centers, our other host, promotes wellness for individuals managing their mental health and operates with a wellness center model to provide services to reach as many community members as possible with peer programs, supported employment, support groups, and much, much more. You can find out more about them by visiting their website, mhcci.com. So coming back to our topic, today we're going to discuss the mental health law known as the Baker Act, as again it pertains to Florida. We'll discuss what it is, how it plays out in real life in Sarasota and Manatee counties, what the limitations are, and some alternatives to the Baker Act. The Baker Act is not always an appropriate, it's not appropriate for every crisis situation, so we'll share some community resources and alternatives. Personally, I have been in this situation many times, forced with the choice of whether to Baker Act my own family member. So I know how important this information is, and we're so happy to have all of you here, and hopefully it will help you with that very hard question, what do we do when our loved one is in crisis? So let me share a little bit about our two speakers today before we turn it over to them. First, you'll get to hear from Lieutenant Charles Kenneth from Kenneth Training and Consulting, recently retired from the Sheriff's Office, but continuing his work to provide de-escalation strategies for law enforcement, first responders, and corporations. Charlie has received numerous citations and awards and is a state recognized expert on special populations and the Baker Act. So since 2003, Charlie's been involved with crisis intervention team training, also known as CIT training. You'll hear that phrase, specifically the Memphis model, and he is a master CIT instructor. What is CIT? Well, CIT, law enforcement officers or crisis intervention team officers, are trained in de-escalating mental health incidents and identifying signs of mental illness when they're responding to calls. And after 8 years on the board of directors with our NAMI Sarasota Manatee County affiliate, Charlie has recently stepped down, but only because he termed out after 8 years. We will miss him, but are happy he's still very involved with our community. He has a lot to share with us today. And then you'll hear from licensed clinical social worker Karen Lord from JFCS Jewish Families and Children's Services. She is the Director of Clinical Services there. She works with teens, adults, and seniors and has specialized training to address trauma and addiction. She has a master's of social work and has completed licensing as an independent clinical social worker, a licensed drug and alcohol counselor, and in addition is a certified addiction professional and qualified supervisor. So she clearly has a passion for helping others and also has a lot of great information to share with us today. And you can find out more about JFCS by visiting their website, jfcs-cares.org. And again, these links I'm mentioning will be available in a slide. So our remaining agenda is we're going to have our 2 speakers, and then we'll have the question and answer portion at the end. As I mentioned, please send us questions all throughout the presentation as you think of them. We'll answer as many as we can. And again, you can do that in the Q&A tab on the Zoom app. So without further ado, we'll get started with our first speaker. I'll turn the Zoom over to Taylor and to Lieutenant Kenneth to get us started.
Well, now, Karen, I guess we can kind of tag team this on that. So,
or yes, or both of you.
Welcome everybody to the webinar. Hopefully, the goals for this webinar that we'll have a little bit more knowledge about the Baker Act laws as it regards to the Florida Mental Health Act, which is affectionately known as the Baker Act. And what you're seeing before you is the 2014 Baker Act Florida Mental Health Manual User Reference Guide. It is available off the DCF website as a PDF. I recommend getting a PDF. I got a paper copy once. It's very good for holding heavy doors open. It is a very thick manual on that. There's a lot in there. So hopefully at the end of the talk, you guys will know a little bit more about how to either get yourself help or what happens when your loved one gets help and possibly is subject to protective custody under the Baker Act. Karen?
Well, I wanted to add it. I thought it was a good slide to start with because the manual, it is a public document. Everybody has access to it, but it is 496 pages long. And you know, when anybody who finds themselves in a situation where they're investigating a Baker Act, it means that things are already probably pretty overwhelming. So we're hoping that this webinar will give a good summary of some of the key points. And then of course, you can access the manual yourself. I included some reference slides at the end of the presentation. They're going to be available to you, and I'm going to reference them periodically as we go through. So when we talk about the Baker Act, it's the informal name of the Florida Mental Health Act of 1971. And so that's an extensive act. The Baker Act, the part we're going to be really focusing on, which is when somebody may be examined for mental health voluntarily or involuntarily. That's a small part of it. But just a little bit of background. The Baker Act came about after many, many years of people, well, to sum it up, basically anybody could be institutionalized with 3 signatures. So if I felt that maybe Charlie needed to be in some inpatient treatment, 3 of us could get our signatures together, and that might cause Charlie to end up in an asylum, sometimes for the rest of his life. And so, and you know, we were talking earlier, unfortunately, psychiatry and mental health treatment has a dark past. There were some atrocities that took place in those institutions that really is a dark mark on our society. And so what happened was, luckily, individuals were aware of this and took steps to really address the problems that were happening in the asylums and the institutions. And part of this was the Florida Mental Health Act. The act focuses quite a bit on how individuals receive mental health care. It focuses on their individual rights, and a key component is a focus on access to treatment regardless of the ability to pay. Because there also was a period of time where people in need of services were triaged based on either insurance or payment. And so some folks who desperately needed help but didn't have payment were left behind, maybe not getting the same types of care that other people had access to. Okay, next slide. So to sum up, what is the Baker Act, which again is the informal name, what we're focusing on is the involuntary examination, and it really is a tool that's used to intervene during a behavioral health emergency when there's an immediate concern for the safety of the individual or bystanders. So it means that in that moment, there's extreme concern that the person's either going to kill themselves or others, harm themselves or others, or because of neglect is in immediate danger of harm.
Yeah, Karen, if I might, the phrase you're going to hear most often associated with the Baker Act will be is that the person was taken into protective custody because they were a danger to themselves or others. That's the terminology that's most frequently used on the forms. And slide.
Mm-hmm.
So behavioral health conditions can meet the criteria and are similar to an emergency situation. And when we talk about a mental health crisis, we're talking about stuff that is basically invisible injuries. We were talking at the prep meeting for the webinars that you can associate the crisis and the emergency health condition of mental illness with that of similar to diabetes. It doesn't always have something. It's not like a broken arm or a cut where someone can say, hey man, you need a couple of stitches and we need to take care of that. Unlike that, where you can refuse treatment, a lot of times the Protective Custody Act is there because if you don't get some type of treatment based upon what we're seeing, your behaviors, your actions, your words, that you become an imminent threat to do harm to yourself or others, or as it says in the slide, significant physical harm to the individual or others around them.
You can also think about it when we talk about the immediacy of it. Sometimes, you know, people who are seeking a Baker Act, they're desperate and they're trying to get help for their loved one. But it's important to understand that you can almost compare it to like going to the emergency room. So if I'm having a heart attack, it's an immediate risk. It's an immediate physical risk. I need to get treatment immediately, or there's going to be death or extreme harm to myself. This is similar to a Baker Act, is that tool where somebody is going to get immediate stabilization for their condition, but with the understanding that they're then going to be discharged to long-term treatment. Just like if I go to the emergency room, they're going to treat the condition I'm having. I'm probably going to need long-term treatment, but I'm not going to be able to live at the hospital to have that take place there. And they're not going to be able to offer me the types of long-term treatment that's going to be ongoing for the rest of my life.
Yeah, and that's very important to note. The Baker Act is often seen as the gateway to getting greater treatment, but it really is only to stabilize the person through the crisis. When we get into the actual time constraints of when they can hold someone, or what the constraints are for when you can execute a court-ordered protective custody or an ex parte, it's only to get the person through the crisis. So it doesn't automatically lead to, if someone, if your loved one is Baker acted, to use the vernacular, or taken into protective custody, it doesn't always lead to a long-term care. They have to voluntarily participate in that. This is for the emergency situation where imminent harm is going to happen without some type of intervention, whether it's by a physician or an authorized provider, whether it's by law enforcement, or whether it's by court order. So that has to be there. And if that crisis passes, then oftentimes that person no longer meets the criteria for the Baker Act. Next one.
I want to talk a little bit about non-emergency versus emergency situations that would warrant Baker Act. Because oftentimes on what would be considered, like Charlie just referenced, meeting the criteria for a Baker Act, sometimes we're having a non-emergency situation that feels like an emergency, but wouldn't necessarily meet criteria. So again, we're talking about a risk of harm to self or others in the present. So past expression of suicidal or homicidal ideation wouldn't meet criteria. Sometimes what happens is a young person will pass a note in school, send a text message to a friend, implying that they want to harm themselves, implying that they want to kill themselves, maybe even that they have a plan. And for a variety of reasons, the friend tells somebody, a teacher finds out, whatever, and without really investigating it too much, because safety is always, and we're going to stress that throughout, safety is always the immediate, that's at the forefront. But they may call in law enforcement or call in somebody for a Baker Act. And then when they meet with the child, they're feeling fine. They don't really know. It was 2 hours ago, they're over it. Sometimes that happens, not always, but when the ideation is in the past and the person's no longer expressing that in the present, they don't meet criteria. Sometimes people make passive statements. I hope I'm hit by a car and killed on my way to work. I'd be perfectly fine if I didn't wake up in the morning. These types of statements wouldn't meet criteria because they're not talking about actually harming themselves. It unfortunately is common for people to have longstanding chronic suicidal ideation without any plan, intent, or means to harm themselves.
Another statement you might get is like, I wish I were dead, or maybe even I wish I wasn't here, as an even more passive or veiled statement. So.
And that's a conversation I have with people quite regularly, along the lines of, do you want to kill yourself? Are you thinking about killing yourself, or do you just want to disappear? And most of the time they say, I just want to disappear. We can work with that. That's something we can definitely work with in treatment outside of a hospital.
Yeah, and Karen, since you opened that door, let's make sure we say this very clearly, is that if you are interacting with and speaking to someone who you believe might be suicidal, don't be afraid. Ask them directly, hey, are you thinking of killing yourself? Don't use cute phrases or saying, like you're doing something dumb or anything like that. If they are, that gives them a natural out to not confront where they're at. Ask them point blank, hey, are you thinking of killing yourself? Are you thinking of suicide? Are you thinking of harming yourself? And get that conversation going. Based upon that answer, like Karen said, she usually gets an answer that says, oh, I just want to disappear. I wish this situation was over. Depending upon the answer that you get, you can then you'll understand whether or not you need to raise the level of assistance that you need. So I just wanted to make sure we got that out there. I know we got another webinar coming in September for Suicide Awareness Month that we'll go over that, but that's very important. Don't be afraid to have that tough conversation. Your friend might be counting on you to have that conversation. Yeah,
I'm so glad you brought that up. The suicide levels are reaching a crisis, they've been at crisis in the country, and it's important for people to get comfortable saying the word, asking people, because when they interview people who have survived an attempt, they almost always say, they felt like they couldn't talk about it. And then when somebody finally asked them, they felt like they were given permission to free themselves of it. And once that's out there, it's something we can work with. It's the secrets that, not talking about it, that sometimes is hard. So I'm glad that came up. Occasionally there'll be explosive episodes that can be very frightening, but may not result in harm to self or others. It may be destroying property, which can turn into another situation, unfortunately, a criminal charge if the person can't calm down. But screaming, arguing, any kind of behavior like that, again, it's always going to come back to harm to self or others. And then it can be quite upsetting when somebody makes a statement or a threat, but with really no intent or means behind it. I want so badly to kill you. I wish you would die. You better watch yourself in your sleep. It's something definitely to explore, but oftentimes these aren't a one-time thing. And if it is a one-time thing, definitely exploring it. But something like that, if the moment has passed, like Charlie had said, and, people arrive to interview and the person's like, no, and there's no apparent reason for concern in that moment, they're not going to meet criteria. Again, we'll warn, like if the person does have a weapon, if they have a history of violence, if they're under the influence of any substances, that's a time to get help immediately.
Correct. Next slide.
And we already touched a little bit on some emergency situations as we were talking about the non-emergencies, but basically current statements or behavior indicating harm to self or others in the moment. If they have access to a weapon, it doesn't have to be in their hand, it could be in the home. And a lot of things in the home could become a weapon. So we want to be aware. You know, sometimes somebody might lock themselves in the room and refuse to communicate with you after they've already been making statements or acting in a way that leads you to believe or leads you to have concern about harm. That would be a time to get help. And then if somebody's impaired either because of substance use or you're noticing a change, they're having delusions, hallucinations, they're not making sense, that is an emergency situation as well. If they can't they're not coherent in communicating with you.
Right, and correct. And we want to make sure that safety is paramount, and it's safety of the person, obviously, if they're threatening themselves or threatening you, but it's also your safety. You have to make sure that you're safe. And then we have to consider the safety of the first responders, whether it is a behavioral health response team coming, whether it is an ambulance coming, whether it is law enforcement coming, whether it is your friend or neighbor or another relative coming. You know, you have to be mindful of the situation. And don't forget is that sometimes if you're arguing or fighting with someone, if you're the person causing that friction, you know, you might not be then the best person to be the healer or give assistance at that point in time. That might be another time where you would access some of the resources we'll talk about at the end of the presentation to get help there, especially if it gets into that active as opposed to passive situation. So active, again, I'm going to do something, I want to do something. Passive, I wish I wasn't here. It would be great if I got hit by a bus. So
that's a really good point because you know, we all have experience with families and like when we care deeply about somebody, sometimes that can unfortunately aggravate the situation if the person doesn't want our help. So sometimes bringing in a neutral party, a third party, can definitely help diffuse the situation when emotions are running high.
yeah. One last thing, we mentioned in there if they're impaired, and certainly we all know certain types of things such as alcohol do lower inhibitions. You do get sometimes courage, and you do things sometimes that you wouldn't normally do were you not under the influence. So in the grand scheme of things, if you're trying to decide whether or not I need more help, if the person you're interacting with is under the influence and they're in crisis, then you probably need to get somebody else there. Very few people in the family situation are trained, quote unquote, to do any type of crisis intervention. In fact, because of the relationships, quite often it falls back into this. Where they're arguing back and forth with each other. So again, if some type of intoxicant is involved, whether it's legal or illegal drugs or alcohol, please make sure that you use that as a factor for you to decide whether or not you need more assistance.
Definitely.
And slide.
I want to talk a little bit about direct versus indirect harm. So the direct harm is the active behavior, thoughts of suicide, homicide, physical violence. So that's something where I can do something to hurt myself or others. And then the indirect harm is there are ways individuals sometimes neglect themselves to a degree where they are at risk of death or serious infection, something that's going to really impact their health negatively in that time. There's the long-term neglect somebody can take that over a long period of time may result in that. It's tricky. It is tricky because, you know, again, people have rights, and we can compare that again to a medical condition. Somebody could not treat a medical condition over a very long period of time, eventually resulting in death. And with in this case, somebody deciding to not take their medication, to not feed themselves properly over a long period of time, it's a little tricky in where that meets criteria.
Yeah, the active is usually pretty easy. That's severe neglect and self-care. It's often brought up in side issues of, well, if somebody's homeless, aren't they neglecting themselves? Some aspect, yes, but are they neglecting themselves to the point where we need to basically take them off of the street and take them and put them into a confined environment? That's usually not the case. And there are plenty of people that are indeed truly nomadic. Not everybody has a camper to go around in. So some people, that's the lifestyle that they choose for whatever reason. So we can't always regulate that into that. So, and I'm guessing slide.
Mhm.
Okay. So the process occurs when an individual is held involuntary for psychiatric concerns. That's what an involuntary examination is. And there are three ways in Florida under the Florida Mental Health Act that they are initiated. One is by a qualified professional. I'll kick that over to Karen to give you the list of that. The second is by a law enforcement officer, usually during an emergency situation. And then the third way is that a loved one or a family member can go to the clerk of the court and file a petition, an ex parte order, and a judge will review their sworn statements and then decide whether or not the person is indeed in crisis and would benefit from a stabilization. And I'll come back, I'll kick this back over to Karen, and then I'll come back and we'll talk about some of the rules and how the law actually reads and governs the powers of each group.
You want to change the slide?
Yeah, oh yeah, I forgot to say
Yeah.
that.
I was just thinking it'd be a good time to launch the poll just to get an idea.
Oh, I thought the poll was launched, I'm sorry.
Oh, no, it wasn't.
Oh, okay, all right. Well, now that we're starting to move into the actual process of issuing Baker Acts, we're going to put a couple of polls out. If you wouldn't mind, for the panelists that are here and can see that, the polls should be a button down underneath your screen, right next to the Q&A and the chat. If you click on the poll and then just go ahead and give us what you think your answer is. Looks like the poll is, okay, the poll's on and going and no one has voted. So we'll continue with the presentation, but please give us a vote and then we'll give you some hard and fast numbers once we're done. I can't get the slide. And Taylor, if you could change the slide. Sharon, that's you. And
Okay. In terms of qualified professionals, this is a list of people who can complete the form to have somebody to do the involuntary examination to have them go to the facility. So these are a clinical psychologist, a clinical social worker, marriage and family therapist, mental health counselor, physician, psychiatric nurse, psychiatrist, all licensed in their fields. Qualified professionals take this very seriously. Anytime we're thinking about an involuntary commitment. So that's basically taking somebody against their will to go to a receiving facility to have an examination. It's very serious because, we always, any qualified professional puts themselves in somebody else's shoes and thinking about when you are in crisis, when I am in crisis, thinking about the fact that I will then, what would it feel like to, you already feel somewhat out of control, then to lose control over your autonomy, over your body, and to be taken somewhere against your will. It's a very serious thing. So it's not done lightly. When a qualified professional is brought in, again, we're always looking for, is this an immediate emergency, harm to self or others? And the other thing we're thinking about is, we all have the understanding that by going to this facility for the examination, it does not mean, it's actually more often the case that it's not going to lead to long-term treatment in the facility. It's going to be a short stabilization. So we're always weighing, is there more, is this going to be a benefit or is this going to be more harmful to the person? Because for a person in crisis, sometimes it can be extraordinarily harmful for them to be taken against their will to a facility and held there, when there are potentially alternatives for safety that we could access in the community. So we're weighing out all those different factors and trying to communicate with the individual as the process is taking place. And one thing I want to mention too, I have a note here down here. I just have to keep minimizing the poll. It's popping up on my screen. When a qualified professional is the person filling out the form for the Baker Act, we need to observe the behavior in the moment. So when we get there, if the person's calm and somebody in the household is reporting that, you know, just a minute ago they were, you know, ABC, and the person is calm, can communicate coherently and says, no, I was upset, now I'm calm, it's not me, then at that point, they wouldn't really meet the criteria. It would definitely be a larger conversation because there's a reason that we were called in, but we would need to observe the behavior. And that's a little different than law enforcement, which I'll hand over to Charlie.
Correct. Just to finish with the professionals, understand is that the professionals do have a 48-hour window, so they can see someone. We see this happening most often at our adult care facilities, where a doctor may come in, see Charlie on Monday, and then Charlie has an episode on Wednesday or Thursday. That's outside of the time, even though Charlie might have a mental illness and they might have discussed possibly a need for protective custody. A professional has to either observe the behavior or be aware of it and have seen it so that they have it in their clinical record. And as Karen said, is that quite often the trauma associated with a can be a 72-hour hold or greater in some cases does more damage to the person with the mental illness than the benefit of the hold. So that's why sometimes there's a disconnect between the families and the professionals we've seen, where families are like, I don't know why Dr. So-and-so didn't write him in, and now this is happening. It's because A, they haven't seen the behavior isn't there, and it might not be good for their treatment plan. The way the statute 394 is written is professionals have in the statute, they may write a protective custody order if the person meets the criteria for that. The same is true, that may is true for judges. They may write an order if the criteria is met. And if we can switch slides. But when we get to law enforcement, okay, when we get to law enforcement, the law enforcement officer doesn't need necessarily to witness the behavior firsthand. They can take credible witness statements. So you can give a statement about your loved one and say, this is what was happening. And crisis intervention team training encourages the officers to investigate all calls as if this was a criminal call, in that manner of, let's see, is there evidence to support what's being said? And the reason we encourage that is because of the fact that frequently the person who is in crisis will deny what happened, or they will try and shift the blame to someone else and go, oh, it's not me. I'm not the crazy one, quote unquote, to use a bad word. It's Karen. Karen's the one with the problem. So we try and get that. So the officers have to conduct an investigation. And if the officers get to the criteria and the crisis is still ongoing, then the statute says that they shall take the person into custody. And that's a big difference, because in legalese, shall means that the officer doesn't have any leeway. They have to do it. We're going to branch off just quickly because we got asked to do this, is that could you please tell us what happens if I need to call for an officer to come to my house? I'm really scared. I don't know what the process is or what's going to happen. Obviously, I'm going to say it again. We've said it all throughout. Safety is paramount. Your safety, the safety of your loved one, the safety of the first responders, the officers coming to your scene. Okay, so if it gets to a point where you have to call, most likely you're calling 911. And when you call 911, the operator is going to ask you a series of questions, and they're going to tell you they want to keep you on the phone. The first thing I have to tell you is that, especially here in Sarasota and Manatee counties, we have premier 911 systems. Our 911, our emergency operations bureaus are nationally accredited, and so they know what they're doing, even if it doesn't sound like it to you. They're going to ask you the questions, and as they're asking you questions, they're building up a screen to get it out, to get either the fire department, to get an ambulance to you, to get a law enforcement officer to you. They're building that screen to get you the resources, and that screen is pretty much gone and sent to dispatch, and someone usually gets on their way within 30 seconds to a minute, depending upon how well the communication is. Obviously, some people who scream are a little bit louder, difficult to hear. Sometimes it might take a little bit longer. They're then going to ask you a series of questions that sometimes our callers get frustrated with. You have to understand is that those series of questions are designed to make sure that the people responding to your emergency are the right people and that they have the right resources. So if we need a fire truck because we need a hose and we need water, we want to send it. If we don't need a fire truck, then we don't want to send it. We might need it somewhere else. Do we need one officer? Do we need two officers? Do we need a CIT officer? That's another question that I get quite frequently. You can ask for a CIT officer if there's one working to respond. Hopefully there is one working, and I can tell you is that it's been the policy of all the law enforcement agencies to try and train all of their first responders, their patrol force in crisis intervention team training. It could happen that those officers are tied up on other emergencies, but it's always good to ask. They're going to ask you to stay on the phone. Please stay on the phone and give them more information. Try and be complete. If someone asks you if Charlie have a weapon, no, Charlie doesn't have a weapon. Then ask you are there weapons in the house. Please make sure that you do that and you answer that question. Because no, he doesn't have a weapon in his hand or anything, but there are guns in the house. Then ask you follow-up questions. Please, again, cooperate with them. The other thing is they want to keep you on the line because until help gets to you, because remember, you've got a person in crisis and then you've been overwhelmed and gone into crisis to where you've now called and initiated an emergency response. They want to try and make sure that you're safe, so they're going to keep you on the phone. So I just wanted to throw that in there. Sometimes we get a lot of questions on that at NAMI. Used to get a lot of questions on that when I was at the sheriff's office. Is that sometimes, you know, just send the fire department, just send them. Well, they're already sending them. They just want to make sure that we're sending them and the right equipment to help you out. We can go to the next slide because I've already mentioned that. Okay, so back up to ex parte. There we go. So a law enforcement officer has to have the criteria be met. We'll go over the criteria again on that, but we boil it down to basically a danger to self or others. If the crisis passes, the officer is going to go there, conduct their investigation, get the credible witnesses, things. If they come to see me and the crisis passes and I am calm and there are other resources and other avenues available, it might not end up in a protective custody. And sometimes that frustrates the loved one or the person who called, going, listen, a half an hour ago, this was happening. Well, that crisis has passed, so we might not take that person into protective custody. If the crisis hasn't passed, if there's enough information to indicate that it's not safe for you or for the person to leave that person in the home or where they're at, whether it's due to danger to self or others or likely to suffer from severe neglect, which is also in the statute, as we mentioned, then that person may come with the law enforcement officer because, again, they have the duty to shall act. When we get to ex partes, an ex parte order is usually filed by a family member who has seen their loved one's behavior changing or decompensating and getting worse and worse, where without intervention, they believe that some tragedy is going to happen, whether it's going to be danger to self, danger to others, or that they're going to suffer from severe neglect. If you need to file an ex parte order, you need to go down to the clerk of the court's office. And I recommend going earlier rather than later in the day. Every effort is made that before the judges go home at the end of the day, that they see all orders that have been filed. I would say you want to try and get that order filed sometime before 3 o'clock. And if there's a clerk online, they want to tell me a different time, that's great. But I know that usually if they get that paperwork submitted by 3 p.m., that usually then it makes it to a judge before they go home. And then that judge will get that paperwork and review it. The paperwork includes a sworn statement that you're going to fill out that you affirm that what you're writing about the behaviors and activities of your loved one is the truth and nothing but the truth. And that your motivations for doing it is to get them some help, because you believe without that help, they'll be in either risk of imminent harm to themselves, someone else, or severe neglect. Once the petition is filed and a judge sees it, the judge will read it. And usually I will tell you is that if you file it, I'll say is that a lot of times the judge will review it and then they will issue it. It's been my experience that they do issue it. I can tell you that there are others that have experiences where they don't issue it. It strictly comes down to your testimony and statement, because the judge isn't seeing the person. Okay, they have to make it based upon what you're writing down there and what you're reporting to them. And it has to convey that the judge who is basically writing what is similar to an arrest warrant, but it is not, but it's similar to in that, because that paperwork is going to go from the judge once he signs it to the sheriff's office for enforcement, for them to go and pick up your loved one and take them to a treatment facility and receiving facility. So effectively, out of the blue, 2 officers are going to show up, knock on the door, go, hey, are you Charlie? Yeah, I'm Charlie. Okay, Charlie, we have a pickup order for you based on a Baker Act petition that's been filed, and we're going to take you into protective custody. And a lot of times that's going to be a big shock and causes a lot of issues on that. Now, much like the professionals, the judge, even though the criteria, you might lay out the criteria, the judge may issue that pickup order, or he may not. And that's strictly based upon what he knows about the situation that you've written into there and anything else he may know about the situation. The last thing is that there are times involved with having them picked up, and usually a Baker Act order is usually only valid for the 72 hours that you would stay in the Baker Act. And that's because if the person is indeed a danger to themselves or others, and we can't find them as law enforcement officers in 72 hours, it's then deemed that that crisis, that emergency has passed, and that the person is back to whatever their functioning level was. Next slide.
Well, I'd like to add one thing to this. In the resource slides at the end of the presentation, I've included a link for a DCF page that once you open that link, you'll see many other links. It can be overwhelming, but I'm going to encourage you, if this is something that an ex parte is something that you think would be appropriate for somebody in your family or a loved one, I'm going to encourage you to look at those different links, because being aware of what the paperwork looks like ahead of time, and even having it partially filled out, or entering things that have been an ongoing concern, can be helpful. Because in a crisis, sometimes it's hard to pull our thoughts together, to get everything together. So it's been recommended that sometimes it's helpful to have a packet prepared, or at least pertinent information that you would need to have on the form, or also just to be aware of what the form looks like. So you'll have access to those, and I would encourage you to check them out. Oh, next slide.
Okay, I think this is you, Karen.
Mm-hmm. All right, so now we're talking a little bit about what is the process of admission. We're going to look at voluntary admission and involuntary admission. So somebody can be admitted to a Baker Act facility either way, voluntarily or involuntarily. Voluntarily or voluntary admission means that the individual displays competence. They're showing that they know what's going on. They can make decisions for themselves. They provide express and informed consent. Informed consent is the person is educated about everything that's happening to them, that's going to happen to them, and they understand. They're saying, yes, I understand. And express consent is providing written, yes, I agree to this. And they need to meet criteria for inpatient examination, meaning that there is that concern of harm. So there are people who will have a conversation with a professional or a law enforcement officer and say, yes, I do feel like I'm going to kill myself tonight. This is happening. And we say, would you like some help? Would you like to go to a facility? And they say, yes, I would. That's the safest place for me right now. And they go. So that's how somebody does, they are admitted voluntarily. So when somebody comes in like that, they're able to communicate, they demonstrate that they know what's going on. They're deemed competent unless proven otherwise. So sometimes people will come in and they're saying, I want to be here, but in talking to them, it's clear that they're not competent. They're either having a psychotic episode, they're confused, they're not actually understanding the process. And at that point, it would change to involuntary. Do you want to add anything?
No, with regards to the voluntary, remember is that voluntary, you can show up. So if you're in crisis yourself, you can show up many places, such as First Step have, and one of our partners, Mental Health Community Center, they have drop-ins where you can come in, or they have services that are available to you. Frequently, we get asked about cost, and we mentioned cost up in the beginning at the introduction. Services, some of the services, depending upon where you're at, are subsidized, and then I can tell you that most of the agencies providing services, they do use a sliding scale. So while yes, psychiatric services and mental health services are expensive, you can still go and get treatment and get assistance and not have it break the bank, so to speak. And the voluntary way, you go in, get treatment, you leave. And some of our providers also now have outpatient services, greater expanded outpatient services than we had previously here in Sarasota. For involuntary, you must have had a psychiatric evaluation for competence within 24 hours. That's there, and after 72 hours, a second examination by a psychiatrist. So what those two things mean is that once you've been taken into the facility, a doctor has to evaluate you within 24 hours. That's part of the Baker Act. That's so you're not sitting there and you're just sitting there and ignored and everything. So if you get taken into involuntary, you get taken into protective custody under involuntary Baker Act, someone with a degree higher than me will do a psychiatric evaluation on you within 24 hours. If they need to keep you longer than 72 hours because you're not stable, a second psychiatrist and petition will have to be filed. We won't necessarily go off into that, but understand is that because this is basically limiting the person's freedom, if you need to be held longer than that standard 72-hour window to stabilize you, because the facility and the doctors there believe that that's necessary and in the best interest to keep you from being a danger to yourself, a danger to others, or suffering from severe neglect, then they have to basically prove it. And for those of you who are familiar with Latin, a habeas corpus hearing would be held if the facility wanted to keep you longer than that, where a magistrate will actually come to the facility and the facility will present its case, and actually the public defender's office will represent the person, and they'll try and work out what's best for the person, whether they stay or whether they go. Understand though, the public defender's position is to make sure that the person's rights are not violated and that they get their due process. And so if they need to stay and the case is presented by the facility, then the magistrate will rule and say they stay. If the case isn't properly presented and they don't need to stay, or it just wasn't properly presented, then they'll be released. And that's what the function of the public defender is in that, just to make sure that no one is basically kept against their will and that they get their due process. Mm-hmm. And yes, the status may change several times during admission, absolutely. That's really because of different things. You know, the person could cycle and suddenly go back into crisis, so they could stabilize and go back into crisis. They might be converted, and oftentimes, especially in law enforcement cases, when we bring somebody in under a law enforcement Baker Act, the facility might convert them to voluntary, and that's just to access funding or their insurances to make sure that they can get the proper treatment. Why do they do that? They're just looking for money, Lieutenant. No, that's not the only reason. Sometimes if as it's been explained to me, if the facility wants to use treatment X or issue drug Y, they have to follow the prescribed regulations of either Medicare, Medicaid, or the insurance companies that are applicable to the subject of the person that's in there. So that's why they have to do that. It's all done with the intent of providing the best care to the person when they're in there by the facilities. Slide. Or Karen, did I forget anything?
Next slide.
I just wanted to say, I think it might be a good time to show those poll results since we're talking about involuntary treatment. And also maybe pull up, I took down the slide really quick, pull up the data that we were sent.
Do you still have it, Taylor? Otherwise I can pull it up.
I do still have it. And since I'm talking, let me share my video. Sorry, it might be a little hard to see me. I'm gonna stop my video and I'm gonna move. But I do still have it. Just from the results from the poll regarding our first question, which was, what is your guess? How many involuntary examinations occurred in Sarasota County in the fiscal year 18 to 19? And our highest amount of guesses were, we had 15 for between 1,000 and 1,800. And then also for Manatee, our highest guess was between 2,600 and 3,400. So let me pull up those results.
While you're doing that, I'm going to answer a couple of the questions. I'll type out some answers to some of the people that have submitted questions while you're getting the screens up. So.
Okay, and it's here. Okay, so as you can see, there's all the counties here, but if we're looking at Sarasota County, the number of involuntary examinations for Sarasota County was 3,821. Here I am. And for Manatee County, the answer was 2,339 individuals. So if you kind of look in the middle section, the blue area, it shows you what percentage was the highest, whether it was by law enforcement, a professional, or an ex parte order. For Manatee County, the highest was law enforcement at 54% of those orders. And then the next was professional at 43%. And then with ex parte order, it was 2%. And I'll also send this out afterwards, but for Sarasota County, it was the highest was the professional, or actually, sorry, the highest was law enforcement. And then right under that was professional. And then with the lowest percent was the ex parte orders. And Charlie, I know there were a few questions in the Q&A while I pull back up that PowerPoint that I believe you're answering.
Are we ready to resume?
Yeah,
Yeah.
we're back. All right, so I'll pick up with treatment. When I talk about treatment, I want to be clear that treatment in a Baker Act facility quite often means something different than people are looking for when they're seeking a Baker Act for their loved one. There's different types of treatment. There's inpatient treatment, both involuntary and voluntary, and then there's outpatient treatment, both involuntary and voluntary. And the next slide will break them down so we can talk about the difference. So involuntary placement, that's usually the idea behind involuntary treatment. Basically to petition the court, and I won't belabor the point because Charlie already talked about this a little bit, but to petition the court for involuntary inpatient services, 2 different psychiatrists have to examine the individual to make sure that they're both concurring on the same things. That express and informed consent cannot be obtained because of incompetence or refusal, and both the psychiatrists are determining that they meet the criteria and they can't be safely treated in a less restrictive level of care. So another term, less restrictive, if you become involved in this process, you'll hear, and it's also in the Mental Health Act, that we're always looking for the least restrictive, most appropriate treatment for an individual. So anything we can do in a less restrictive environment is what we're going to do, as long as it's safe to access that level of care. So somebody who is going to be placed involuntarily, it means that it's been determined that they can't safely be outside of the facility at that time.
Now, let me just segue into this because it's a question we always get at NAMI, is that we called law enforcement to respond, and they took my loved one under protective custody under the Baker Act, and they put handcuffs on him, and it says they're supposed to do least restrictive treatment. Please understand is that the law enforcement, they're not providing treatment, they're providing transport too. So even though they do an evaluation, they take your loved one into protective custody, they follow the policies and procedures to make sure that everybody's safe. And so, yes, it is absolutely horrible that that your loved one is going for treatment and has to ride either in the back of a police car or has to ride in handcuffs. We do have a transportation exception plan in place in Sarasota County, which does allow for an ambulance transport, but the person has to be stable and nonviolent and cooperative in order for that to happen. And so oftentimes that's not what law enforcement encounters. And so they will put handcuffs on there, but they're not involved in the treatment. So they're not running afoul of the statute.
And that's a really good point, because it's such a stressful situation, and having a mental illness is not a crime. Wanting to kill yourself is not a crime. Wanting to kill somebody else because you're having a mental emergency, a mental health emergency, not a crime. But when the police arrive, they're trained to protect everybody. And sometimes that means protecting one person from another, other times protecting somebody from themselves. And unfortunately, sometimes restraints have to be used, because when police arrive, people have an indication, they understand that something's about to happen. And sometimes they're trying to run. Sometimes they become combative out of fear or paranoia, or a variety of different factors. I know personally, if somebody's trying to hold me down, I'm trying to get out. And a police officer, again, isn't a trained professional. And sometimes it's even a trained professional wouldn't be able to diffuse the situation. And that's when, unfortunately, sometimes restraints are used. It's always difficult for everybody.
Yeah, it is. It is.
For sure. Next slide. I created a little bit of a comparison between inpatient services and outpatient services. So when we're looking at these petitions for people to have involuntary services, inpatient is usually determined to be most appropriate if the person has an extremely high level of risk for safety. They need increased security, because in a facility, they're going to be supervised 24/7. So there's staff rotating, checking on them throughout the night to make sure that they're safe. That's going to happen in an inpatient facility. And then they also have increased continued access to the treatment team and medication, where outside of a facility, they might not be able to obtain medication. And especially when people come into a facility and they are experiencing a psychotic episode, meaning they're unstable because of a chemical imbalance, they need to have a treatment team balancing out their medication to help them stabilize so that they can leave the facility. And so it's usually a better plan to have them in the facility until they're stable. Somebody would be have involuntary service, outpatient services ordered, typically when they have a long history of non-compliance with outpatient services. So in the past, it may have been recommended, it may have even been ordered, but the person chose or was either unable to participate or follow through, or they did not want to. So this would be a person who needs ongoing structure, needs a higher level of care, yet doesn't need that 24-hour security and safety monitoring for involuntary. Do you want to add anything, Charlie?
No, I think believe it or not, I don't have anything to add. So I know some people that know me will say you have nothing to say, but no, you've covered it all, Karen.
Next slide, please. I want to go back to inpatient treatment because the word treatment is used a lot. And sometimes people who are desperately trying to help their loved ones, they really hold out hope that if the person can get into a facility, they're going to be able to get the treatment they need. But you'll find that when when treatment is used as a term for inpatient services, it usually is specifically for supervision, stabilization, medication management, and discharge planning. That's the treatment. So it's not going to be the longer term ongoing skill development, coping skills, and all the things somebody needs to learn to manage. It's going to be very short-term emergency stabilization services. Next slide, please. This slide, it's a little busy. I wanted to put the criteria so that you could see it when somebody is ordered to involuntary outpatient, because this is another outpatient treatment. I should have written. This is a place where people really hold out hope. Again, outpatient typically involves more intensive services. So they think if my loved one is ordered to outpatient, it's going to help them get well, which may be the case. There are a lot of criteria that somebody has to meet in order to have this order for involuntary outpatient treatment. They've got to be at least 18 years old and diagnosed with a mental illness, and they have to meet clinical criteria for an intensive outpatient program. And those criteria vary. Also, and they have a history of non-compliance with treatment for mental illness that can be demonstrated. And they have to have been non-compliant with treatment due to impaired judgment resulting from mental illness. And, next slide, have either been involuntarily admitted to a receiving treatment facility through a Baker Act or received corrective mental services 2 times in the last 3 years, or engaged in at least 1 serious act of violence towards self or others in the last 3 years. And they also have to be able to benefit from the services offered in the program identified. So I wanted to spell it out because there's a lot of different things they have to meet, because if they don't meet any of those ands, then they're not going to meet criteria for this order.
Correct. And what I want to take everybody back just for a second, because somebody sent me a prompt and reminded me, is that, what are we looking for? How do we know somebody's just in crisis? Is it just that they're just crying and upset? And basically what you're going to look for is signs and symptoms. And signs, just like stop signs, are outward things that you can see. Symptoms are what the person is going to tell you that they're feeling or they're experiencing. So if someone were to tell you they're hallucinating, well, why are they hallucinating? And if they're hallucinating and they're not under the influence of anything that would cause a hallucination, then that might be them telling you that symptom, they're telling you, yeah, I'm seeing a dragon fly around, and the sign might be them ducking down to avoid the dragon, what you might see. So when you go and you are going to either write your ex parte order, you're going to be a credible witness for the law enforcement officer, or you just want to know what they're looking at and what they're trying to evaluate. They're looking for signs and symptoms, hallucinations, delusions, different than hallucinations. Delusions are fixed false beliefs. So I'm Napoleon or something along those lines. And obviously we're going to assess for a suicide risk. The individual rights that Karen mentioned in the beginning are extremely important. There are several federal and state laws that are out there to protect individual rights. And the Baker Act is set for persons who, when the officer gets there, he doesn't have to know that you have a mental illness. Just based upon his observations, the credible witness, he has a reason to believe that the person has a mental illness. And because of that mental illness, they either need to get treatment and they won't get treatment, or they don't know, they're not able to make that decision. And then without that treatment, they're going to be a harm to themselves or others, or suffer from severe neglect. So I wanted to go back and make sure everybody's got that on the statute on that. The other thing that I wanted to make sure I mentioned is that the Baker Act doesn't cover the infirmities of aging. It doesn't cover intellectual disabilities. It doesn't cover developmental disabilities specifically. So you can't be Baker Acted because you have dementia. You can't be Baker Acted because you've got Alzheimer's or because you've got autism. Now, that's not to say, and that's why I precluded this with the signs and the symptoms, that's not to say that someone who has any of those developmental disabilities or a traumatic brain injury can't then exhibit those signs and symptoms and be subject to a Baker Act. That just can't be the reason for it. So you cannot have a Baker, you can't call up and go 911, what's the emergency? Please send somebody by. Charlie is autistic and he needs to be Baker acted because he's autistic and I can't take it anymore and everything. That would not qualify. If the behaviors are directly related to the infirmities of aging, organic brain disorders, developmental disabilities, intellectual developmental disabilities, then that doesn't qualify. And the last one to add in is that frequently it's substance use or substance abuses is prevalent in people who have mental illness. It's usually because of stigma. That's another webinar that we do about stigma, but it's usually because of stigma. And sometimes it is because you can get alcohol cheaper or illicit drugs cheaper than you can get the medicines to treat your psychiatric diagnosis. So sometimes they self-medicate. There is a chance of things being co-occurring, meaning that you've got a mental illness and a substance abuse problem. That would be a separate some webinar not covered by NAMI that would cover the Marchman Act, which is the Florida Statute 396, which covers substance use and substance abuse. Very lucky in Sarasota is that now it's one door if you go into First Step, but if you end up at one of the treatment facilities and they determine that this is a mental health issue, then they're going to get you mental health treatment. If you end up and they determine it's a substance use issue here in Sarasota, then they're going to get you a substance abuse treatment. So I just wanted to bring that back. I got a text from somebody saying, hey, can you just expand on that a little bit more? And I wanted to just put that out there. So Karen, is there anything you wanted to add to that?
Yep.
Charlie and Karen, and everyone, I know we're going to get to a lot of the questions, but I think this one goes directly with what you were just saying. There's a question that says, how do we protect children that are rightfully or wrongfully Baker acted while at school? Some cases I have seen, children are wrongfully Baker acted and they are disabled, autism, and more times than not, the parents are not contacted in these situations. So are there safeguards against this or to counter this to assure that there is not physical or emotional trauma?
I'll just say this much, is that's a much larger question to answer than we're going to be able to do. But I will say this much is that, yes, there have been strides made and changes made to recognize what's going on with our children and to try and make sure that if the Baker Act is used, it is the last resort for law enforcement to take the child out of the school. And again, because if the law enforcement takes it, I mean, now you have this kid who's young, impressionable, they're still getting their attachments and their imprints from growing up. And we're going to create a very poor image. With regards to it being other, whether their behavior is related to other diagnoses such as autism or developmental disability, or an intellectual disability, the schools should be aware of that. Much like stigma, sometimes people don't want to admit that. I've seen it on both ends where some people fully understand and they told their child they're different. Some people have said no, they're not going to tell their child that they're different, but you have to tell the school. That's what I would encourage you to do. And there's nothing that would preclude you in those situations from coming up and contacting the school counselors and trying to set up some type of a safety plan, telling your school what soothes your child best because you know your child best. And then obviously the last bit is as a responsible parent, trying to ensure that your child understands what's the expected behaviors at school, just as they do at the table if they're sitting at the table, or at the ball field if they're playing a game on a team sport. But that, unfortunately, that question is beyond the capabilities of this webinar. I think you'd agree with that, Karen. No?
Yeah, and I mean, parents absolutely have to be involved. And the other thing is, this is where, because there's, I'm not sure exactly who's in the audience, but I believe there's probably a wide range of people with different experiences. But in terms of when we talk about an inappropriate Baker Act, I mean, there's obviously people that really are suffering with chronic persistent mental illness. It's a different category than the inappropriate Baker Acts that happen in school settings regularly, because they don't know what else to do if the child's trying to leave the building, or having one of those explosive episodes I referenced early on in the presentation. So they decide, let's do a Baker Act. And sometimes what happens is this starts to set up the cycle of what we sometimes refer to as institutionalization. There's a buildup, there's an explosion, there's a Baker Act, there's the cool off period while everybody's separated, and then they go back into the environment and it starts over. And that's sometimes a lack of resources, a lack of education, a lack of support. And that's what I think Charlie meant when, you know, it's a larger problem that is being talked about, though. And I think that's a step in the right direction, that it's a conversation that's taking place about different needs, because it's a short-term emergency crisis tool. It's not a long-term solution for anybody.
Yes, and if I may, I'll throw a plug in there, is that, and that's why organizations such as NAMI, who brought you the webinar tonight, it's important for you guys to volunteer and to support NAMI and help us. We have an advocacy wing. NAMI has local affiliates, NAMI Sarasota Manatee. We have a state affiliate, NAMI Florida, and there's NAMI National. And all of them are busy working at our state capitals, working in Washington, to try and get laws to get parity for mental health treatment and get the equity that has long been missing for persons with all across the disability spectrum, including mental health and substance abuse issues.
Yeah. Okay, next slide, please. So when we talk about treatment and discharge planning, I just want to be clear that discharge planning starts on the day of admission. So the moment somebody enters a facility, the people on the treatment team are already preparing for discharge. And the reason I want to stress this is, again, to just be clear that the long-term ongoing treatment that somebody with mental illness needs is it's not going to be available in that facility. There are some long-term facilities left. That's not going to be part of the webinar. I don't have a lot of experience with them. They're few and far in between for public facilities. But in terms of discharge planning and treatment, really, it's always looking at the moment somebody comes in, how can we work with them to develop a treatment plan that is acceptable to the individual, because that's critical. And you know, that's how we operate at my agency, JFCS. We're a person-centered, we offer person-centered treatment, meaning really understanding that the person is the expert on their life and they're going to identify what's going to be helpful to them and what's not going to be helpful. And that's really going to help them be invested in, you know, working on different solutions to get to where they want to be. So in the facilities, that's also their approach. What would be helpful to this person according to them? Or in some cases, when they can't make those decisions, they do have somebody assisting them in decision-making process, working together for that treatment plan. But the treatment plan is always going to be, where can this person go? What can this person do outside of the facility? So it's always going to be looking at outpatient services. And I want to step back when I talked about court-ordered outpatient treatment or ongoing services. I just want to be clear with that too. It can be a way to help people get to treatment who otherwise would not go. However, as I said, having a mental illness isn't a crime. And even when somebody's court ordered, it doesn't mean they're going to go. And if they do go to satisfy the requirements of the order, it doesn't mean that they're going to participate. So, you know, community-based treatment is always trying to engage individuals to find, you know, what would be helpful to them. But in some cases, even ordered, people won't engage for a variety of factors. Okay, next slide. And this leads to some alternatives. These are alternatives to the Baker Act, but they also can be used. Sorry, message on my screen. They also can be used after the fact in terms of aftercare. But alternatives to avoid a Baker Act when it's not something that's absolutely necessary for safety in the moment, communication is key. And this goes back to something, well, Charlie brought it up and I mentioned it, really getting comfortable talking about difficult topics, getting comfortable saying the word suicide, getting comfortable asking the question, do you feel like you want to hurt yourself? Do you feel like you'd rather be dead? Do you feel like you need some help? Or practicing expressing concern. And I'm sure many of you in the audience have already had these difficult conversations. You're well versed in it, but this extends into the community as well, helping people outside of the mental health field get comfortable talking about these things. Because sometimes, like Charlie said, if you ask a person, or you say to them, I'm concerned and I'm worried, are you feeling like you want to kill yourself? And they say yes, you have options, because they don't necessarily have to go to a Baker Act facility or get engaged that way. You can start to talk about it and ask them, what do you need to be safe tonight? What can we do together? How can I support you? Or who can I bring in to support you? Because sometimes when we're the closest to that person, it's too much. They can't take the help from us. They want to get it from a more neutral party. So communication's key. People can voluntarily seek evaluation or treatment outside of the Baker Act. So this could be calling a mental health center for an appointment to get connected to a counselor. There's the suicide helpline. There's the community mental health center. There's other places that people can engage to get support when it's a non-emergency, to get support for long-term services without having to go through a Baker Act. There's many voluntary services in the community. When it does feel like an emergency is building up, there's the mobile response team out of First Step, and I've included their information in the resource slide as well. This is a wonderful service that can be an alternative to calling the police. As I noted at the bottom of the slide, if it's a case of an emergency or an immediate safety concern, you always want to call the police. We talked about the different emergency examples in the beginning. But if it's a situation that's escalating into crisis and you're worried about somebody's safety, but feel that in the immediate environment, things are okay, you can contact the mobile response team. It's a team of mental health professionals. They'll respond within an hour to call you back to talk to you about what's going on. And then they can come out and evaluate your loved one, the person you're concerned about, to determine if it's a crisis. And then they can help you either de-escalate the crisis and develop a safety plan and get connected to community resources for the long term, or they can determine if you do in fact need to go the route of a Baker Act. So it's a wonderful community resource that you can access rather than having to call the police in a situation where there's not an immediate concern about danger.
Yep.
Informal supervision means engaging family or friends to help support the person in the moment. There are cases where somebody might express, I do feel like I want to kill myself. I don't think I'm going to be able to get through the night. And by talking about it, sometimes we find that we can bring family members in, friends of the person, to sit with them overnight, or just to be with them on an ongoing kind of 24-hour watch until the crisis passes, and while they're trying to engage community alternatives rather than going to the hospital. This isn't always a solution, but in some cases, if it's a minor, the parents can clear any weapons from the house. They can kind of take shifts sitting up, being awake with the individual. With adults, you can have friends come and stay at the house, family. Again, I understand not everybody has that kind of support network, but it is something that it can be an option in some cases. The outpatient counseling services I alluded to in talking about voluntary services. There's a variety of counseling centers in Sarasota and Manatee that anybody can access. There's also many private practitioners. Unfortunately, sometimes finances do dictate where somebody goes. However, a lot of the public facilities do have sliding scale fees and have grant funding, and a lot of places, JFCS included, we don't want financial situations to be a barrier to anybody getting treatment. So reaching out for support, even early on, if you can have a conversation with your loved one and, see if they'd be willing to just go talk to somebody and letting them know, accessing voluntary outpatient counseling services, you're not making a long-term commitment. You can go once, twice, you can meet with a clinician. If you feel like it's not a good fit with that person, they'll find you somebody else you can talk to, really just working to get the person the appropriate support. Respite service, or respite as an alternative. Again, I understand that not everybody has this, the ability to access respite. And I think that would be something that would be a wonderful benefit in talking about parity for mental health, increasing access to respite, because sometimes families do need a break from one another to be able to, sort things out, calm down. And so being able to separate sometimes can be helpful. And rather than doing it by going to a Baker Act facility, if it's a young person, if they can go stay with another family member, if it's adults, roommates, or a couple, if there's another place one person can go stay until the crisis passes, that can be helpful. And then when I put in family support, what I meant is that support for the loved ones of the individual who is afflicted with mental illness and really struggling in and out of crisis. It's very stressful to watch somebody that we care about decompensate and engage in self-destructive behaviors, especially when we've been watching this for a long time. They may have been in and out of facilities and we're trying so desperately to help them, and nothing seems to be working. It can be just so devastating to a family and to an individual. So I encourage anybody who's in that situation, who's just feeling helpless and overwhelmed, like you're banging your head against a wall, to reach out to community resources like NAMI, possibly getting some counseling support for yourself. There's different groups like Al-Anon and Nar-Anon, groups for people who maybe suspect they might be engaging in codependency and trying to help their loved one. There's different community resources. And I think sometimes the family members are so focused on helping the person that they care about that they overlook their own needs and how painful this is for them. So I just want to let you know that making sure you're taking care of yourself is critical as you're going through this process with your loved one. Charlie, do you want to add anything to that?
No, I think we can skip into the resources. That'll leave us about 7 or 8 minutes for any questions. I've been trying to answer some questions on the Q&A as quickly as I can, but I don't know if Shay is going to have any questions. But these are our resources that we've got out here. And again, we've mentioned some of them. We don't specifically always mention providers unless they're partnered with us at the time, but First Step is out there, Bayside is out there as well. We can probably go to the next page. Here's a view.
The link for DCF on the page before, that link will bring you to a page full of links. It's on one slide back. But that will bring you to the one at the bottom. Yeah, that'll bring you to a page with the ex parte. It also has a link where you can see the forms that the professionals fill out when they are doing a Baker Act. And that it just might be helpful to increase your understanding of the process and the information that's gathered.
I'll speak to that. That specific link goes to the forms on that one. But if you go to the DCF website, the My Family's website, they have plenty of training on all sorts of topics, including those of you who had specific questions about children. They have training on the resources available for children, suicide prevention, mental health, mental wellness. It really is a font of good, solid information. So please go to there.
Yeah, it's all public and free.
Yep, it is absolutely public and free. So it doesn't cost you anything.
In this last resource, I included the directions too, because this is a site, the Florida Certification Board. It's typically courses and different certification development for professionals. However, the instructions guide you through, if you create an account, it's free. You can access the course called Introduction to the Baker Act, and sometimes it says or refresher. And that will be a more in-depth walk through the Baker Act. It's about 6 hours long, but it's done. It says it in the beginning, they say it's for professionals, but also for family members who want to learn more about the process. It's very easy to understand terms and a really good walkthrough, and you can access it anytime, and it is free. So that's available to you as well. It's for the public.
Well, great. Well, thank you. Thank you, Karen and Charlie. That was all amazing information. A lot of great information, a lot to unpack. We have just a few minutes left, so let's get into some more of the Q&A here. A lot of great questions. We'll try to get to as many as we can. Anything that we can't answer here, I will try to get you answers later, and anything that we just can't answer because we don't have the knowledge, we'll try to get you a resource for that. So here's a good one. You mentioned involuntary services a few times. In Sarasota County, how likely is it that a Baker Act would actually lead to discharge to any kind of involuntary commitment facility?
Not very likely.
I heard it was unlikely.
Yeah, not very likely at all. Remember is that the Baker Act and the treatment facilities, it's just to stabilize the person through the crisis they've got. It would take a lot more, for lack of a better word, and forgive my police experience, evidence that the person needs a greater / higher level of care that's going to restrict their freedom. That would need to be presented both either to the professional who would have to sign it, and then you have to find a facility as well. So not often. Usually the Baker Act is just designed to get the person through the crisis and then hopefully get them into some type of outpatient care to keep them stable.
And part of that too is, we are looking at the individual's rights, and they have the right to determine what they feel is appropriate for themselves. So if they're coherent and they're demonstrating the ability to make a decision, it might greatly vary from the decisions or the choices we think would be better for them. Like they might be choosing to live outside. They might be choosing to continue to use drugs, and they might be choosing not to take their medication because it makes them feel terrible. And while we know that that's detrimental to their health, if they can communicate that, like, I know that I'm doing this and I don't care, then it's accepted that they have the right to make that decision.
And here's another one. Is the family member or loved one involved if there is a court hearing that decides how long they will be held or where they will go after? Is there any family member involved or loved one involvement?
I think that's going to depend on if the family member has been named the guardian or the health proxy, the person determined to make decisions. But if the individual says, I do not want my mother present, or I do not want my brother present in the courtroom, or my family, and they don't have any legal connection into the decision-making process, then I don't believe they're invited into the courtroom. Charlie, do you want to add to that?
Yeah, usually witnesses are not brought in for that magistrate hearing, but that's not to say that they can't submit information in. They usually are not aware of it. And that comes down to the confidentiality laws of client and facility, and whether or not they allow participation into it. I always say this is that while doctor or professional treating your loved one cannot tell you what's going on with them unless absent specific permission is given, they can listen. With regards to that hearing, if you've already been making that connection with the facility and you know that the hearing is coming up, then there should be an avenue for you to get some information to them. In most cases, no one knows about it. The loved one's in there, and they'll find out when Charlie's released and when Charlie comes knocking on the door or calls for a ride home. So.
And one other thing too, in terms of an individual's rights, they do have the right to communicate with their family. So throughout the process, so if they want to speak to a family member, unless the facility determines that it's unsafe for some reason or there's extenuating circumstances, then they will be able to make a phone call or communicate with their family member. They have that right.
Okay, let's see here. Charlie, this one might be for you or either, really. My loved one was arrested in a crisis, just arrested. Is there a way to make the criminal justice system aware of their mental health issues?
Well, obviously, it depends upon the circumstances of the arrest, and we don't. If training and consulting doesn't give legal advice or medical advice on that, but But there, again, much like talking to the facility, you can contact the booking of the jails usually and give them information about the person when they're in there. It just depends on the charges and the nature of what's going on, whether or not that is even going to be a factor on it. So again, it's a larger question. I can tell you is that CIT training is working towards expanding that. And most of your law enforcement agencies, there's 2 sheriff's offices in Manatee and Sarasota, they train their corrections deputies in CIT, and they have medical staff on scene. So if your loved one exhibits the signs and symptoms, they should probably be identified and will be addressed appropriately, hopefully.
Well, we have answered some of the questions here. I do want to be respectful of people's time, and we are at our ending time. Charlie was able to answer a bunch of questions in the Q&A section while we went. So what we're going to do is go ahead and wrap up, and then we will try to get any unanswered questions answered directly to everyone. So thank you all for attending. It has been so wonderful to have everyone here, so many participants. You know, big round of applause for our speakers and to Taylor for making it all happen. I know we gave you a lot of information. It's a lot to unpack in one sitting. So I'm sure you have questions. Please reach out to us. Stay tuned for some more webinars on this topic. If there was something specifically we did not cover that you would like to see in an upcoming webinar, do let us know. There's going to be a short survey at the end where you can include any more questions that you have. So please take a look at that survey. And please, Karen mentioned some of this, please get help for yourselves and your family members. You can come to family support groups or family education through NAMI, and of course peer groups and services at both NAMI and MHCC, and it looks like mental health counseling services at JFCS. Thank you to everyone and have a wonderful evening.
Just a reminder, this will be sent out to those who weren't able to attend, and then also everyone will get the recording and it'll be posted on our website as well. Thank you.
Thanks, everyone.
Thank you very much. Be safe, everyone.
Be safe.